most people around the globe have seen various headlines about the ongoing war with Ukraine and sanctions. This article that you can see on your screens at the moment concerned the Russian oligarch who had connections to the HS2 contractor, Strabag. I'm going to touch on a number of matters, and I'm going to talk about sanctions in a minute in more detail. What you must do, though, is consider what are the causes of your problems. So some things will be related directly to sanctions and some aren't. So, for example, some of the volatility in the marketplace with materials isn't caused by sanctions. It might be caused by other matters, such as scarcity of products, shipping supplies. And it's important to be able to understand what are the driving factors of your problems. The war in Ukraine has led to various particular issues. So, for example, we're aware of the wheat issue. Ukraine supplied a lot of the world's wheat. It's also supplies a significant amount of timber, and there's talk about these being covered by UK and EU sanctions in the future. So the first part of the talk is just looking at the problems of sanctions from a UK perspective, and it's really more to give contractors, clients and subcontractors some sort of guidance on what's happening in terms of sanctions, what they need to look out for, and also what some of the standard forms provide for. So sanctions can apply to an individual, organisation or legal entity, and they're designated by the government, and the government produce lists of these people. These lists can be easily accessed on government websites. You're not going to have all of these sanctions applicable to your projects, but you should certainly be aware of them. We've seen sanctions applied across the globe at different times. So not only do we have sanctions against Russian oligarchs and Russian companies and financial institutions, but there have been other ones such as the Afghanistan sanctions, Zimbabwe sanctions, and also in Iran there were a number of sanctions that were imposed over there that impacted things. You'll be getting a copy of the slides afterwards, or be able to access a copy of the slides afterwards. So I don't want you to take down notes, but there are websites which will tell you the various sanctions. So essentially there's a number of enabling acts that were passed by the UK government, and then each time they add more people to sanctions, they then tend to do it by way of a regulation being passed, which will update and say the actual entities that are sanctioned and what the sanctions are. Now, some people think that it's a minor matter to float a sanction. It's not. Some of the economic fines can be quite high, but also there's a risk of imprisonment. So, for example, the breach of sanctions asset freezing on the screen at the moment could carry an imprisonment of a term of 7 years on indictment. Even if it was dealt with in the magistrate's court, you could look at a maximum sentence of 12 months. Breaches of controls on importing goods similarly have imprisonment terms, and there's also fines that can be applied. Now, it's important to recognise that it's not only UK sanctions that apply in the United Kingdom. Other countries have various sanctions regimes, which include the United States, the United Nations and the EU. And if you breach any of those sanctions, you could be liable under their local criminal courts. Also, what you could put yourself at risk of is that you lose your banking, insurance and financial services, because if you're seen as breaking sanctions, banks won't deal with you. They can't afford to take the risk. Bond providers won't want to deal with you, and insurers won't be able to deal with you. So it's quite important to be aware of the sanctions. In the United Kingdom, most people, when they get you to tender for a job, will ask you to make a binding offer capable of acceptance. So this is a warning. If you are going to submit a binding offer, you must be happy with all the contract terms and conditions. You must not submit a qualified bid if you believe that the contract will not provide provisions for a change in law, fluctuations, labour and material shortages. So it's extremely important that people take care when tendering for work and understanding what they're submitting. In terms of the UK, we're going to quickly look at the FIDIC, JCT and NEC, what they provide for in terms of change of law legislation. And just before I do that, I'm going to ask David to say a few words about sanctions and some of the issues.
Certainly. I mean, thank you, Sean. You've covered most of the broad issues, but I think we were talking before this webinar began. In some ways, sanctions are based in statute, statutory instruments, treaties, other regulations. And it's almost worth thinking of sanctions like taxes. The source of sanctions, because they're in regulations and specific regulations, are very precisely drafted. If they catch you, they do so. If they don't, they don't. And so, for example, turning around to an employer, if you're a contractor, and saying, look, I'm sorry, Uncle, but there's Ukraine war, so there are sanctions, actually isn't good enough. You have to deal with your obligations under sanctions very precisely in terms of saying that you can't do something, or in terms of what you can do. Some years ago, when there were sanctions in relation to Libya, I had to advise on the interrelationship, as Sean has identified, between the US sanctions regime and at that time the EU sanctions regime, which informed the UK sanctions regime. And the export that we were dealing with was the export of compressors. Compressors weren't sanctioned, pumps were. And we had to very precisely draft submissions to the relevant authorities that we were dealing with compressors and not pumps. Now, I realize that for the engineers who are sitting on this call, that's a fairly obvious distinction. If you try and put fluid through a compressor, you blow it up. But actually looking at the definition of compressors and pumps in the regulations was not quite so straightforward. So teasing things out in that way it needs a degree of precision. The other thing that I think Sean identifies quite rightly is the way in which a lot of sanctions are promulgated. And this will come on to when we look at change of law provisions. But again, there's a temptation to say there is a war in Ukraine, or in relation to other change of law, there's been COVID. But in fact, there may not be a change of law in certain circumstances, because depending on how change of law is defined, yes, introduction of primary legislation may be straightforward. But a lot of sanctions regimes, as Sean says, there is the underlying statutory regime which operates, and then delegated legislation may be made. But again, the delegated legislation may put in place a framework that may be sufficient to catch you, or it may not. If you're dealing with an individual who is sanctioned in terms of trade, as we're seeing with the war in Ukraine and Russian individuals, sometimes those individuals are simply added to lists which are effectively under the control of a minister now, or a Secretary of State. That may constitute a change of law, but it will depend on the drafting of the change of law provision. And if in fact the change of law provision doesn't go low enough in terms of regulations, a simple designation of an individual may not constitute a change of law, because in fact the law has stayed the same. The law is simply that you can't trade with individuals who are identified by the Secretary of State from time to time. So you need a great deal of care and precision when dealing with sanctions, sanctioned individuals, sanctioned imports, sanctioned exports. And it really is, this really is one of those areas where simply saying X is going on, there's the war in Ukraine, trade with Russia is being sanctioned, that really isn't enough. This is an area where the devil is very much in the detail. John.
Thanks, David. So I'm going to look firstly at the FIDIC Red Book. not used that often in the United Kingdom, though you do see it being used. You see the Yellow Book, which has similar provisions. So in that particular contract, it does provide for adjustments and changes in legislation, but the contractor's entitlement is subject to them complying with the contractor's claims clause at 20.1, and it's for changes in legislation that affect the performance of the contractor. So if you haven't been able to demonstrate that your performance has been affected, you might not get relief. What you do get, though, is time and possibly cost, but obviously you're going to have to keep records and demonstrate that. The FIDIC forms of contract, if they're used in the United Kingdom, would possibly therefore give you time and money. But obviously, because they're territorial in application, it's only changes in legislation by the UK government. So, for example, the US sanctions, the UN sanctions wouldn't give you any relief, and you wouldn't get time or money if they were to impact you. JCT similarly has a change in law provision in the unamended form, and that similarly is an exercise after the base date by the United Kingdom of any statutory power, which directly affects the execution of the works. So once again, you'd have to demonstrate how it impacted your works. If it doesn't directly affect it, if there was an indirect effect, it may not be covered by that provision. JCT similarly will give you time. It doesn't give you cost under that particular provision. And similarly, if it was a UK site, only UK government changes in legislation would grant you any entitlement. So once again, you could be exposed to US, UN, or other country sanctions and have no remedy. The NEC form of contract, the NEC4, the modern version of NEC, as people say, it's been around for 5 years, but it's only just starting to be used on projects. In that particular contract, you have to choose an option, and it's X2, which deals with changes of law, but that only applies to the country in which the site is located. That will give you a compensation event, so it could give you time and cost, but once again, it's got to have been in the country where the legislation applies.
And I think, Sean, that geographic limitation is very important for people who are running projects, because if you've got NEC4 and option X2, and in fact you are doing design work or fabrication work in Germany, for example, you might find that you're actually restricted in terms of carrying out works in Germany, but it doesn't apply because it's not a UK. If it's a UK site, it's not a place where the site is situated.
Yeah.
So you can have that kind of mismatch on what is a fairly typical modern project.
I've got to be honest, David, that most of the projects I see, they have labour from across the world, they have materials from across the world. You know, it could be a simple housing site in the United Kingdom, in one of the local towns, and quite often the products have come from across the globe.
Yeah.
So NEC4 could give you time and money, but once again, it's territorial in its application. So if it's a UK project, UK site, it needs to be UK legislation. But people overseas do use NEC4. So for example, in Hong Kong, it would be the local legislation in Hong Kong. If it was a site in South Africa, similarly, you could be covered if there was changes in South African legislation. What you won't get, though, is if there's a change in South African legislation, you won't get it if the project's in the UK. So I can't emphasize enough, it's territorial application, and people must understand this. The next slide reinforces this. It's territorial in application. So you must be careful about other countries' sanctions and trading blocs such as the EU and the United Nations. If you think this is going to be a problem, you need to negotiate. So whether law changes are included in the contract, this means that you're going to need to make amendments to the contract. So as I touched upon before, if you're submitting a binding offer and you haven't got those provisions in there, they're not going to be included. And my suggestion would be that that's something that you must amend. We've entered a period of great volatility and flux in the market. It's not like previous times where you might have been able to get free. without some sort of financial impact. And I think it's extremely important that people look at this. Clients are aware of it, consultants are aware of it, contractors and subcontractors, because it's going to impact all of you, and it's going to impact your relationships, and it can affect not just the project you're currently delivering, but other projects in the future. For example, if your relationships break down. Another important thing to emphasize is the base date is key. If there's a sanction that's already in force and your contract was entered into after that sanction, you've got no relief. So do make sure that you understand what the sanctions regime is at the time of the contract and the particular base date, and also understand the legislation. Had it been passed? Was it in force? There's a whole range of things that you need to look at. Obviously, if you're not sure about sanctions and their implications, you need to seek legal advice, because what you don't want to do is fall foul of them. As I touched upon before, the penalties are quite severe. Also, you could lose your banking and financial facilities and insurance facilities, and that would be detrimental to any company.
I think, Sean, it's also important that people are very careful that something has risen to the level of a change in law for their contract. And what I have in mind there, which I've seen, is price changes and tariff changes for imports and exports and that sort of thing, where in fact the owner and the contractor, not in the UK, but in jurisdictions where things are sometimes done much more informally, there has been an anticipated change in a tariff. And in fact, the change in the tariff may have been published in some informal document, so a trade document or a website or something. Everyone's then gone off and behaved as if that change in price has occurred, except the government hasn't actually promulgated it. So the question then arises, actually the wrong sum has been paid. Had there been a change of law, the correct sum would have been paid because it would have responded. But in that circumstance, everyone would be proceeding for a period on the wrong basis. So again, you've got to be very, very careful about what people are doing, and assuming that something is just happening because it obviously is. This is very much about the detail of what's actually being done.
Thanks for that, David. As I put on the slide, other provisions in the contracts may be of assistance, and that could be with the standard terms or particular conditions that have been negotiated. Don't think that there's one way to necessarily skin a cat. The talks emphasise change in legislation, and that's because there's a lot of concern about that particular aspect at the moment, but there are other provisions in most of the standard forms that you possibly might get some relief free. I'm now going to invite David to address you.
Thank you, Sean. Sorry, my screen stopped sharing by the host, but I'll carry on anyway. Before I jump into the FIDIC implications of this interesting question, I just want to set a bit of context around Vietnam. But when I use Vietnam as an example, I think I'm using Vietnam as a civil law country. I'm using Vietnam as a country that doesn't have any sanctions with Russia or any other countries due to the present crisis, and that's because geopolitical relationships. Vietnam is actually an ally of Russia. In fact, the Russian foreign minister was in Hanoi last week. So we certainly don't have any sanctions with Russia, and there's a long Soviet-Vietnam relationship. However, what we'll go through today is that there is a knock-on effect. So sanctions in the US or EU or UK for that matter will eventually impact us here. The saying goes, if China catches a cold, we all get the flu. So basically it's the same for Vietnam. We're heavily reliant on the rest of the world, the global village as we call it. So therefore, please bear that in mind when I'm referring to Vietnam. So we're not as heavily sanctioned as Sean's slide right up at the front, where clearly there's a lot of restrictions in place. So moving on, we just next slide, Sean. So I want to go through this fairly quickly, but I want to go through a quick 101 on FIDIC for those people that don't know FIDIC very well. I want to demonstrate the golden principles of FIDIC, which they introduced 2 years ago. I want to try and convey to you the difference between civil law and common law jurisdictions. Basically, under the wide ambit of, under civil law jurisdictions, there's a very wide ambit of the law, and we'll go through that in later slides. And then quickly look at the FIDIC clauses that Sean's touched on, and then look at, is FIDIC default version fairly balanced, and what is the reality in practice? So that's what I'll tend to cover. So for those of you not too familiar, these are the main books: red, yellow, silver, gold. Red is just no design, employer design. Yellow book is design and build. Silver is the GMP turnkey, and the gold book, not so often very used. These books, as we'll see, have the same structure clauses. These books here on this slide are for MDB projects, which is government projects, which is the projects I normally work on. Here in Vietnam, it's a lot of ODA funded projects for infrastructure. ODA meaning official development aid. That means JICA from Japan, or Asia Development Bank, or indeed World Bank. So I'm very much familiar with the MDB Pink Book, which is a derivative of the Red Book. Short form, we never really used that. It's less than 500,000, consultant agreement, and then the new Emerald Book. The point is, on all these slides, on all these contracts, the structure is the same. The risk is very, very different, however. Red Book is probably the lowest risk because the contractor gets paid for every square meter or cubic meter he builds. Design and build, more risky. Silver Book, increasing on the risk scale, but you're getting a increased employer certainty further down the scale. You see the top arrow to the right. You're getting a lump sum price, GMP, with the yellow and silver, but on the Red Book, you're just getting remeasured. These are quite important when we talk about FIDIC, changes allowed under FIDIC for variations, etc., and claims. Next slide. So here's the structure. Across the whole suite, very, very similar. I don't need really to go into the different constituent parts in this talk, but what I do want to identify as in red, the particular conditions of contract. Next slide. FIDIC has always set itself out as being clear and transparent, consistency of structure across the forms, it's flexible in civil law and common law jurisdictions, and it's equitable. The outcome is not always the same, but we're not here to debate the success or failures of FIDIC in this talk. We're just here to try and dive into whether the FIDIC is a fair, balanced contract. That's certainly what the general conditions of contract attempt to do, but what we'll see is the particular conditions of contract sometimes alter that balance of risk. Next slide. So 2019, the golden principles, just to quickly go through the particular conditions. GP1, duties, rights, and obligations, roles, and responsibilities must be generally as implied as the general conditions. GP3, the particular conditions must not change the balance of risk or reward. This is like the golden principles that we're expected to follow. However, the reality is not always quite the same. Next slide. I'm not going to go through the balancing act of risks, but you will have seen these risk rules before. But this is really what I'm driving at in terms of when we see particular conditions drafted, we're not always getting a balance of risk. And I've identified a bit later on some clauses or particular conditions that tend to have attempted to push risk of law changes back onto the contractor. As Sean pointed out, FIDIC default version gives relief, time and cost. But the particular conditions, employers or the drafters of the contract sometimes try to dilute that and actually push it back onto the contractor. So as Sean intimated in one of his slides, when you're tendering a project, you're bidding a project, need to read the small print, especially in the PCCs. Next slide. So FIDIC is normally used in countries that don't have their own standard form. Obviously, UK has its own standard form, the US has its own standard form, Singapore, Hong Kong. You don't see FIDIC being used so much. It's used in countries such as UAE, Ukraine, Czech Republic, Russia, South America, and Vietnam. But it is adopted by World Bank and MDBs. Therefore, it's very, very widely used. Next slide. Right, so the governing laws, just to start with the definition. The law controls the validity, the application, interpretation, and enforcement of the contract. It's a very wide-ranging ambit of implications based on the law. Subclause 1.4 of the FIDIC books state the contract shall be governed by the law of the country or others stated in the particular conditions. So in exceptional circumstances, you may get a contract in a geographic location using a different law. We in Vietnam have to use Vietnam law, but when I first arrived in Vietnam, some employers were tempted to say Singapore law applies or Hong Kong law applies. That was very early days, but that's obviously been now it's impossible to change the law of contract as a part different from Vietnam law. The laws apply to all sorts of things, not just pricing, but also construction permits, design codes, penalties, defects, limitations are all mandated by the law. So very far-reaching implications if the law changes during your contract after the base date. It affects many, many things apart, not only the cost. The law is promulgated by different authorities. It's not set out in a civil law country. We have tax officials, we have statutory authorities, we have public authorities, we have health authorities. In fact, FIDIC 2017 refers to regulatory authorities, health authorities, and legally constituted public authorities. All these entities have a control over the contract. If the law changes or one of these bodies changes a provision or a requirement that covers your contract, that's going to have an impact on your tender price maybe and your time for completion. Next. So this slide is just basically there to demonstrate that in civil law countries, we have very, very many different bodies. Ministry of Construction, Ministry of Trade, Industry and Trade, Ministry of Transportation. I've worked on several projects recently in infrastructure, and the project is impacted by MOC, Ministry of Trade, Ministry of Planning and Investment, and oftentimes the law can be used as a sword and a shield in terms of trying to enforce an issue or trying to reduce a claim, and therefore can be quite punitive unless you've got very, very strong legal advice on the implications of law on the project that impacts your project. Next slide. Right, so we stated right at the beginning that changes legislation does allow is an adjustment under the contract 13.7. So there we summarize the different provisions that allow adjustments: 13.1 VOs, remeasurement, value engineering, currency, provisional sums, and the last two, 13.7 and 13.8, are what the two changes that were relevant today. Next slide. Again, this just summarizes the fact that the accepted contract amount doesn't change, that always stays the same, but it may be adjusted under these various provisions to reflect what is called the contract price. 13.7 and 13.8 again highlighted, and we'll go through those a little bit more detail later. Right, so I pulled this one. This is under my first reality check, shall we say. I pulled this literally from a project I'm working on this week, in fact. And the drafters have said that all legislation, regulations issued by the National Assembly of Vietnam, the Standing Committee of the National Assembly, the Government of Vietnam, and other authority to issue any legislation or regulation, or it goes on, enforce from time to time, including but not limited to laws, ordinance, decrees, circulars, decisions, standards, regulations. It's like a big shopping list of laws, shall we say, that will impact the contractor. So the contractor has to look into a huge crystal ball and price for all these potential provisions under the law. So this for me was like, whoa, they've really thrown the kitchen sink in here. But if you're working in a civil law country, this is the wide ambit of laws that apply to you. Hence risk. Next slide. Again, PCC in the project I'm working with, if I just concentrate on the red words, they've actually added of Vietnam or outside of the country. including without limitation, import duties, import value-added tax, VAT, excise duties, personal income tax. Again, this is what I call a kitchen sink clause. They've literally tried to throw everything at the contractor and say, you're responsible for pricing this in your tender offer. I'll leave it to others to decide whether that's fair and reasonable. I've certainly tried to negotiate this clause out of the contract, and those discussions will be taking place probably when I get back to Vietnam next week. Next slide. Price adjustments. So, as I said at the beginning, we're not actually directly impacted by sanctions. However, we are impacted by global supply chains. So the contractors will either have signed a lump sum contract where they're not entitled to changes in pricing, or they will have signed up to a cost reimbursement contract by inserting clause 13.7 or 13.8 in the appendix. The mechanism used is indices. Questionable whether these indices work, and the last 3 arbitration cases I've worked on have all been about price adjustment. The indices have not provided, in the contractor's opinion, adequate recovery of his cost increases. So we get into the realms of, are the indices adequate? Are they complete? Are they available? And often the question cannot be resolved at project level, because these indices are published by government bodies. In fact, they're published by different provinces in Vietnam. So for a change of an indice, you actually need a change of contract amendment to use a proxy indice, for example, a GSO index or something like that. So lots of trouble, lots of problems, lots of risk with price adjustments. Question arises: if my steel price has increased by, say, 20% since I signed the contract because of China steel prices, the cause and effect needs to be looked at, investigated. The event happened in China. It's been passed down the supply chain to Vietnam. Can we apply the price adjustment clause? Can we claim extra over the price adjustment clause, saying the indices are no longer suitable, or can we claim force majeure? Again, we'll talk about that a bit later. Indices do not try to reduce commercial hardship. So oftentimes we see contractors trying to use this clause, saying simply to trying to get a bit more recovery on increasing costs of the key materials, reinforcement, concrete, aggregate, sand, and feel that they have not received that recovery under the indices in the appendix. So in Vietnam and probably other civil law countries, provisional laws may also have an impact. So contractors need to be aware. Next clause, next slide. Force majeure. We spoke about this just before the webinar started. FIDIC does allow for relief for force majeure, as do most contracts, and they have a 4-point test. The 4-point test is usual. The event must be beyond the party's control, not reasonably provided for in the tender, it was unavoidable, and cannot be attributed to any one party. But it must have due proper notice, and of course, there's a duty to mitigate. War, hostilities, whether declared or not, invasion act or foreign enemies is actually one of the events under the clause 19 of FIDIC. So therefore, this event in Ukraine, the war in Ukraine, is definitely covered under this. However, we need to look very carefully, not only at the contract, but also at local laws. I investigated in advance of this webinar and found that there's a civil code and numerous decrees, circulars issued by the Ministry of Construction, Ministry of Planning and Investment, again, have their own guidance and rules and laws on the enforcement of force majeure clauses. Interestingly, all of those documents in Vietnam include war and hostilities. So, in conclusion, if a contractor gets into difficulty in terms of commercial pressure due to insufficient prices in his tender and increases in rates, he has 2 options. If he signed a price adjustment contract, he can use his indices. If he finds those indices are no longer applicable, he tends to demonstrate that and actually get a change in law or get an amendment to the contract and asked to use proxy indices. not always easy to get. And in the cases I've worked on, it's been not been agreed upon, and therefore the contractors have to wear the cost. The other, as I just mentioned, force majeure. We need to look at where the cause and effect, and we need to investigate, does the law in Vietnam or any other country allow a claim if the event is outside the geographical coverage of that country? So obviously Ukraine war is outside the Vietnam arena, but can claims for force majeure be successful? There's not a great deal of precedent on this, so we cannot be conclusive on that. But these are the discussion points that will be probably debated in any arbitration by the legal counsel. So that's very quick. That's a very quick summary of FIDIC and how it treats implication of change in law. My main takeaways are: civil law countries, beware. It's a myriad of different entities who can have an impact on your contract. It's not going to be so straightforward as maybe a UK or a Singapore or Hong Kong law, which is based on common law. And all these implications need to be investigated by legal counsel and advice before you sign the contract. Otherwise, as a contractor, you're probably into a big crystal ball gazing exercise to make sure you've got your costs covered. Or you can provide a caveat, commercial condition before you sign. So that's really enough for me, Sean, at this point. I'm happy to jump back in for any particular questions.
Thanks for that, David. I've got a question from Kieran. Can you, during negotiations, get more than one jurisdiction law to apply? For example, if you're manufacturing in Asia, but site works are in the UK, and if so, which country legislation takes precedence if there is a contradiction?
I suspect this one's for me. I teach my arbitration students that, in fact, an arbitration can have up to 7 or 8 laws applicable to it. And that may be without negotiation, that may be just by the operation of the various laws. So you can have a contract. The idea of having a contract with more than one applicable law in the choice of law clause, I think, would be very difficult. Because really of the issues that Kieran identifies, where there are sort of which would take precedence, which would govern. And after all, your relationship with the customer will have a single nexus. So on Kieran's example, you're manufacturing in Asia, but site works are in the UK. At that point, you're still delivering to the customer in the UK. But taking the UK example and tipping it on its head, what you can't do if you've got site works in the UK is say, well, we will submit this to French law or some other law, and we will thereby have a pay when paid or pay when certified clause, which would be prohibited under the Housing Grants Construction Act. And that's because the Housing Grants Act applies where the construction operations are in the UK. So in those circumstances, that would be a clash between a chosen law and a mandatory law. You've chosen French law for many purposes, but actually English law says, no, because the construction operations are in the UK, you can't have a pay when paid or pay when certified clause. So you might end up with that anyway. You could, in theory, split your contract into different obligations. So to come back to Kieran's example, if you were manufacturing and supplying goods that you were then installing in the UK, in theory, you could take your contract, you'd probably split it into 2 contracts. And you could say to the contractor, to the employer, all right, we're going to manufacture these goods in Asia. We will deliver these goods to you in Asia. You, the employer, will then ship those goods, redeliver them to us on site, and we will install them. And at that point, you could have a sale of goods contract that was subject to one law, construction contract which was subject to a different law. You could do that. Can't quite think why you would, but you could. But as I say, the bigger one to watch out for, Kieran, is where you've got a choice of law, one law, and then mandatory law that also that cuts over. A mandatory law, as its name suggests, it will prevail.
There's a lot of debate, isn't there, David, at the moment, that English law provides more certainty of outcome, whereas a lot of the civil code countries can give you more wriggle room or more options when problems arise. Yes,
I think that's right. I mean, I would say this, wouldn't I, because I'm an English lawyer, but I think there is more wiggle room the back end with liquidated damages. Those of us who do work in the Middle East are very familiar with the idea that tribunals can adjust liquidated damages, either, well, in theory, in either direction, and that can be a surprise to people. You also find, in fact, that there are theories that use obligations of good faith to bring in pricing and quoting pre-contract to some civil law contracts in terms of outcome. And I have seen an arbitration in relation to a very large upstream energy facility in South America, which was subject to civil law, one of the laws of Latin America. Pricing had gone through the roof for various reasons, force majeure, other raw material prices, all those sorts of issues. And the owner was saying, no, you had obligations to at least price within certain parameters if you were pricing in good faith, in a way that, from a common law perspective, was much more, well, hold on, everyone's at risk when you're initially pricing, both the owner and the contractor. You then come to whatever the contractual pricing is, whatever the contractual pricing adjustment mechanisms are, and that's what you set forth on. Much more wiggle room, as you say, on civil law.
Yeah, I've heard that from a lot of people, that a lot of clients are trying to discourage use of civil. So even people that wouldn't necessarily have chosen English law previously now are looking at choosing English law.
And I think you get that from the common law. So you, to an extent, from New York law, but not so commonly used internationally. English law, Singapore law, same thing under the law of New South Wales. Law of New South Wales will give you that sort of certainty, but it's that common law thread gives people the contractual certainty where they want to legislate for what's going to happen.
Yeah. So I don't think that we've got any other questions. If anyone would like to pose a question, we've obviously got a question and answer box. Do post the questions in there.
Anything in chat or?
Nothing really in chat. I think there's no, it's just observations more than questions in chat. I saw you made some notes, David, and I know that you wanted to say
yes. I mean,
share some observations.
It is interesting. David's observations as to law and compliance with law is interesting, because it's one of those things that for a contractor can cut both ways. You have to comply, as I said in reply to Kieran's answer, with mandatory law. So if you're executing a contract in Vietnam, you've got to comply with those laws anyway. If you're dealing with a change of law, however, that's an entitlement under the contract to change time, price, because of a contractual change in law. So if a change in law clause simply said law for these purposes means statutory legislation, then anything done by the bodies that David identified, you'd still have to comply with them because they have power in Vietnam to make you comply. But in circumstances where something was promulgated by particularly something like the health ministry, which you've got to deal with. I mean, that's what a lot of the COVID disputes were. But something that's promulgated by the health ministry, you would have to comply with it. You would want to be able to point to a very broad definition of law and laws, and say, look, just because it's been promulgated by the local health official, it's still a change in law. I still get change time, change money. So it's interesting. That sort of broad definition can sometimes work in contractors' favor. The other one that I was looking at was a very broad definition of taxes. And it always amazes me. Taxes is one of those things you see, the definitions that you see are like the definition that David's put in his slide, which is, tax, levy, impost, duty, other charge, or withholding of a similar nature. And you think that's an incredibly broad definition, and then with incredible frequency, someone comes along and the contractor is suffering some charge, and the owner says, well, that's not a tax. So that's one of those ones where you have to be very careful about taxes, I think, in terms of what constitutes a tax and what entitles you to compensation for it. But then it really does come back to these various changes, comes back to what Sean's been talking about and what David's been talking about, which is tracking through the detail of the consequences. So we were talking, and it all comes back. It's like a broken record. It's always about records and baselines.
Yeah.
For contractors, but it really is. So to give an example from the UK that I dealt with post-COVID, we had a change of law, which was essentially the social distancing regulations that were imposed in the UK on site. And in fact, there were issues in the UK because sometimes the UK helpfully tried to exempt construction industry, or in England and Wales, they exempted the construction industry, which wasn't helpful because things still applied, but owners were then saying, well, hang on, the construction industry's been exempted. But we had to rejig site on site to allow for social distancing in enclosed spaces. So work was suspended, site was reconfigured, work was remobilized. So far, so good. Everyone knew what was going on. There was 2 weeks of delay. Everyone dealt with that. By reconfiguring work practices for the following 18 months, we had enormous problems with productivity. The number of, quite literally, the number of welders we could have on given work fronts was halved. So actually, our claim wasn't a classic delay claim because we did accelerate, but it was a productivity claim rather than a delay claim. And so we were back to, fortunately, that job had been underway for a number of months. So we had measured mile progress and productivity from before COVID. But tracking through and saying, well, it wasn't enough. And I think this is what's caught people for the last couple of years. It's not enough to say there was COVID, so it's cost us money. They really are the classic global claims. This is the change of law. This is exactly what the regulation was. This is exactly the change on site that regulation led to. This is then the delay or the disruption that on site led to. This is the expense, and that's the difficult one. And this is the time. Tracking through to those ends, I think, is what is very, very important for these kinds of claims at the moment. And it's going to be exactly the same with Crimea in terms of tracking through the consequences. And for example, it's going to be saying, this is the change of law because of sanctions. This is what we therefore couldn't ship or couldn't procure. This is the change in price. And this is why we get it, rather than going somewhere else and reprocuring from the United States rather than Ukraine. Proving that causation is going to be an issue.
So you've got cause, effect, and records. You need to demonstrate all of those.
You need to demonstrate all of those, just like anything else.
Yeah, I think that's going to be key. we have got a period of volatility. People are going to be pushed. So even if you've got a very friendly and helpful client, even they've got to find the money from somewhere if they're paying the contractor. And I think they're going to need to have the evidence to allow them to consider it. If you present it well in theory and they're acting fairly, you should be able to resolve the matter. Obviously, if you've got someone who's been unfair, you're going to be then looking to go towards your dispute resolution procedures and quite likely to end up in an arbitration.
But ultimately, when you're in front of an adjudicator or in front of an arbitrator, they're going to have to understand exactly those things. What are the records? What do the records show in terms of event, cause, consequences?
Yeah. So we've got a question. Would it be standard practice to work under Scottish law for a contract in England for a Scottish client? And then the second part of the question is it acceptable to request English law?
You could. You will still have the Construction Act under Scots law or English law, different courts. And then you could use Scots law for a project in England. Certainly, a number of occasions, I've seen people using English law for projects in Scotland. What you may need to be careful about is also selecting in that circumstance which court or arbitrator has jurisdiction over that. In particular, which court, what is the seat of the arbitration? If you've got an arbitration, or does it go to the English courts or the Scots courts? Because you could, if you selected the TCC, for example, or English High Court, you could end up in front of the English TCC, but asking them to apply Scots law, which they'd be able to do. English courts can apply what in that circumstance would technically be a foreign law. But yes, you could.
And I've also seen that some of the Scottish A&Bs have been named in English, or contracts being carried out in England. So I was nominated by the Chartered Institute of Arbitrators Scottish branch,
right,
because the client was from Scotland, and that was a default A&B that they put in all their contracts. So you do get these elements. It can cause confusion. It can lead to cost as well. So if I was working as a subcontractor or a contractor, and it was quite a low value project, I probably wouldn't want to have another law. I want English law and go to an English court.
Because if you're an English subcontractor, you'd want to go to your regular solicitor rather than having to go to someone in Edinburgh who would be perfectly, very, very good, but to advise you on what is a subtly different law.
Yeah.
And for example, without heading off down a completely different rabbit hole, concurrency under English law and concurrency under Scots law have dealt with different.
Yeah.
So it could make a material difference there.
David Lockwood, obviously you've got wide experience across Southeast Asia. What governing laws have you seen there? Do they tend to use the governing law of the country they're in, or say, for example, do they choose English law?
Yes. Well, when I first arrived in Vietnam in the sort of mid to late 90s, the Vietnam law was not as developed as it is now. For example, it was only in the year 2000 that there was the enterprise corporation law where private companies were allowed since 2000. So over the last 20 odd years, the law has developed. However, so when I first arrived, the contract might say something like Vietnam law shall apply, except where it's silent, Singapore law will apply. So you had a balance. They tried to have two laws. Yeah. Those clauses have completely disappeared now. Vietnam law applies all the time, and you cannot enforce another law. So it's changed. And of course, in Singapore, more developed countries, Singapore, Hong Kong, it's always going to be the law of the country where the project is, without exception. I would have thought, David. I haven't seen dual laws in those sort of countries. Have you?
No, I mean, you sometimes see, I was just thinking about your observation, Kieran's observation, you will sometimes see an onshore and an offshore element to a large contract. So you might, to come back to Kieran's question, you might have construction of a power station in an electricity power plant in Vietnam, where everything would be onshore, would be subject to the law of Vietnam, but actually the turbine supply contract might be kept offshore and subject to English law, with the turbines being supplied sort of FOB wherever and then shipped into Vietnam. By the time they get to Vietnam, they're already owned by the owner.
I've seen projects in Asia that have been a real mess in terms of the different laws that applied. So there was a number of Japanese companies that had formed a JV. Their JV agreement between themselves was under Japanese law, which has quite a long period of limitation for breach of contract. They then contracted with an Indian JV doing work in India. There's a Contracts Act in India, which has quite a short limitation period. They then had another contract with a client under English law. Some of the suppliers in the project were under Spanish law, New York law.
Yeah. And
none of the limitation periods lined up. So you had to do a matrix to work out who you needed to fall out with first. So,
yes,
you know, people do need to give thought to choice of governing law, because it can cause some unfortunate problems later on.
And it can, particularly with limitation, it can lead to insuperable problems in terms of moving risk around, particularly a complex matrix of joint ventures and contracts like that.
Yeah. And I suppose we're seeing that now. In the UK, we're obviously doing a lot of mega projects at the moment. And they've got some quite complex JVs with very big supply chains that span the globe. So yeah, it's all things that need to be taken into account.